I'm Lee Moyer. I represent the Electoral Intellectual Well-Being Committee headed by Emily. Now, if you don't know what that means, just think of it as the S&W Committee. That's the smarter and wiser. Our goal is to make you smarter and wiser. And your attendance here shows that we probably have a group of you who are certainly interested in this topic. I was motivated to suggest to the committee that this is something we should do, and there are a couple of things that have prompted me to do that. The first one was the one that I outlined in last month's connection. Do you remember where the person got swindled out of $23,500, my friend? Well, that was one of the things. In case you don't remember it, this was a friend whose wife handled all of the financial things, everything, on the computer, and she's excellent at it. Unfortunately, she passed away, but she knew she was passing away, so at least she gave him the passwords for all of the things she needed. So he was well equipped to do that when she passed away. The only thing is, she didn't give him all the things that might occur. So it wasn't long after she passed away that he got a text message, no, it was an email from PayPal. And they said to him, have you posted a $1 charge recently? Yes or no, please respond. He responded, got involved with somebody. It cost him $23,500, which he'll never get back. So be sure that the person who's going to be handling the signatures has enough information that at least they can deal with a little bit of swindlers. The second one happened to me just recently. My brother-in-law, who lived in South Carolina, 95-year-old person, passed away, and he knew he was. But he had family in northern New York, where a family cemetery was, and so he had given instructions that to be sure that he was buried up in that cemetery. He even took her to the place so she knew where she was. So he passed away, and there all of a sudden she's got his instructions that he wants to be buried 500 miles away, and here she's got a dead body. They had never talked about how to get it there. So fortunately, she and her son didn't see. Well, the only thing that really made any sense was for a cremation and getting the ashes there. But that shows me how couples can be and expect the other person to either know. And the thing that puzzles me is that we have spent our lives keeping our family, our children, our spouse, and everybody from having to face events that we knew that we could do something about. And yet somehow, the matter of what happens after we pass away, we so often ignore and let it up to them. And then I saw a statistic that said that 40% of all people, all seniors in the United States under 65, over 65, 40% have no wills. And that shocked me about that. So all of those put together is the impetus for today's session. At the end of today's session, if you don't have a will, you're not going to be able to write one. There's no way that Michelle is going to give you enough information that you can sit at your computer and do your will, that's for sure. What we're hoping today is that we're going to give you enough information that you can evaluate what you have done so far and see whether it stands the test of time for tomorrow. One of the problems with death is we know we all share that in common, and it's inevitable, because we're going to die. The only problem about that is we don't know when. If we knew it was going to happen next week, maybe there's some things we would do a little slowly. So, knowing that that's something we all share, it's something that we all should be facing and doing something about. I tried to think of why people would not have a will, why that 40%. I came up with these. First of all, the word estate. People say, have you planned for your estate? And when you say estate, you probably think what I do. A mansion with a big wall up there and a gate that flows open, it's controlled. That's an estate. Well, it is an estate, but if you look in the dictionary, you'll find out that estate also means anything that's left over when you pass away. So we're going to use that definition as the one, and not scare you away from estate planning, regardless of how little or how much you have. The last reason that I think people stay away from it, it's complicated, and it's challenging, and it takes time, and it takes money. Let's say it's not going to be done for free, even if you do it on the internet. So, the only thing that we faced then was how are we going to present that to the residents here at Frederick? And so the name of Michelle Forsell came up. And so we have her today. I'm going to introduce Michelle to you as two people. First of all, Michelle represents us and has represented us for the last 10 years on the Frederick Board of Living. Probably very few of us know that, but she has. So first of all, let's thank Michelle for serving us for all these years. Now, Michelle, as an attorney, she is a seasoned lawyer in senior law, estate planning, and in administration of that. She's part of the Cross and Machete law firm team, which has a branch in Pennsburg. And Michelle lives in Pennsburg, and she is part of that. So she's close by. And we're trying to do this today in a question and answer. So on his first plan, it was simple. You people would provide the questions, I'd read them and give them to Michelle. There was a problem. Only 2 of you sent me any. So I'm going to do like they do with the Abbey in the newspaper every day. You know, if you don't get a letter, you make one that you think represents them. So all except 2 questions today are some that I think are the ones that you would ask if you were sitting here in my place with Michelle in an office all by yourself. So, Michelle, the very first question that we have for you is, how did you get involved in being an estate planning attorney rather than a regular attorney that you once were?
Hi everyone, can you guys hear me okay? Yeah. Okay, good. So it is my absolute pleasure to be here today. I always enjoy coming over to Frederick, and I really enjoy my interaction with you guys as a resident, so thank you for having me. And I get that question a lot. Why do I do what I do? I do it because I love it. If I didn't, I would do something different. And for me, it's helping people. That's how I was raised. You always volunteer here and there, and you do what you can to make life easier and better for people. And that's how I ended up starting with the basics, with the estate planning. And the need was my senior clients, I didn't have the knowledge at that point years ago to take them that next step. And so I would refer them to colleagues of mine that were in different offices, different cities. Not a single one of my clients went. It was too far. They weren't going to leave town, whatever the reason was. So by necessity, I said, well, then let's figure this out. If they're coming to me and asking me those questions, well, then let's learn how to do it, and let's find a way to do it. So my staff and I have really focused on doing what we can do to keep everything in one place for you. And so that does involve the estate planning, which are going to be your wills, power of attorneys, your health care. It's going to be trust. It's going to be the administration. But the elder law piece of it is also the long-term care planning. How do we pay for care? Do we go into a retirement community? Well, most of you are here because you live here, so you've already made that decision. But I have so many clients that need to talk it through. They don't know where they should go, and they're not willing to give up, their home, and it's scary for them. And I think that's one of the reasons, too, that when Lee was talking about why people don't do their estate planning, they're afraid. Nobody wants to come to me and talk about these topics. Let's face it, this is not a pretty topic. It's not exciting. It's not pleasant. It's very hard to think about what's going to happen to us or what's happened to other family members and how to avoid all that stuff. And so I try to make my job is, let's try to make it as easy and as friendly as possible, because this is tough stuff. But I do what I do because I love it.
Thanks, Michelle. And what can you do for us? What can an estate attorney do to help us?
Absolutely. So from a basic starting point, we always talk about the 3 basic documents. Your will, for when we're not here. Healthcare. Healthcare is 2 parts, because that's going to talk about who can talk to our doctors today. But it also lets us decide what kind of care do we want in those last hours, in those last moments. And then, of course, we have our financial power of attorney to deal with all of our assets when we're living and we need help. That's our starting point. But then you take it a next step and say, all right, well, how do we do the advanced planning? Do we need to take care of people who have special needs, who have addiction issues, who are minors, who are just bad with money? Those are all advanced planning, because then we can set up trusts for them already, we can fund them already, and we also help figure out, like I said, where are you guys going to live? How are you going to pay for your health care? All of those types of things are things that I deal with.
How about wills? Is that a good place to start?
Very good place to start. So we always first talk about, why do we need a will? Which is really, what happens if we don't have one? That's really the big question everybody wants to know. Because a lot of times I have couples who think, well, we're married, everything goes to each other. Well, not really, because we have to follow the state statute if there's no will. And if a spouse passes and there's children, guess what? The surviving spouse has to share it with the children. If there's also a parent of that spouse, they're sharing it with that in-law. So that's where the law really can be tricky, because we have to go through the entire family tree to figure out where things are going to go. That may not be what you want. That's why the will is so important, because you get to control it. Where do you want things going? Who do you want to be in charge? So that's always a good idea to have something, even if it's a basic will, just something so that you can control that part of your future when you're not here.
What happens if you don't have a will?
Then we have a big mess. So I'll give you this example. I had one
Well,
gentleman.
does everybody need a will?
They do, even if they have one penny. Because we often find things later when the person has passed that need to be dealt with. And without the will, we're drawing the family tree again to figure out who's in charge and who can inherit. I had one person who had passed away. He was an only child, no will, no spouse, no children. His parents were already gone. Each of his parents had 7 siblings, and they had children. I had to get through 40 individuals and figure out who was living, who was deceased, and who could still inherit. That's a lot. That may not have been who that individual would have wanted his things to go to. That's why it's so critical that even if you think you don't have anything, what you do, there's something that's going to go somewhere, and we might need somebody in charge of it.
So does Pennsylvania have a will for people who don't have a will?
Pennsylvania doesn't. What they do is they create the statute that tells us where things go, drawing that family tree. What Pennsylvania has is a statute that tells us what needs to be in the will if we have one. So that's where everything comes down to what the legislature decided is important. And we have lots of rules for that.
Like, give an example of what happens.
Well, we want to make sure that we have everything that should be in the will by the statute. So that's going to be things like not only who our executor is, how things are divided, it's going to talk about tax clauses, it's going to talk about authority for the executor, what we're going to let them do or not do. And the most important piece of that is, should the will be witnessed? Yeah, absolutely. But does it have to be notarized? Not really, but the state again has rules. And it tells us who can be a witness, who can be the notary, who can't be. So those are all the requirements for an actual will, make it much more complicated than trying to write it up yourself, because we have to follow those state statutes. Because if it doesn't, I often have people who have passed with a will that I'm holding in my hand, and I can't use it because it does not meet the state requirements. And again, back to the state statute, back to who you might not want to be in charge.
So you're saying that if I don't have a will, someone else is going to decide where my assets are going?
The state statute will, yep.
Okay, you said it needs to be witnessed by someone. If that person passes away, what do we do?
That's why it's always best to have the will notarized. Because if your will only has witnesses and no notary, when we're ready to use the will after you pass, we've got to track those witnesses down. We have to explain to the court, where are they now? Why are they not here? Did they pass away? Did they retire from where they worked? Why can't we find them? And then we still have to find 2 witnesses at the time to say, yes, they recognize your signature. Always best to have your will notarized. Then we don't have to do all those extra steps. That's why I notarize all my wills.
And who notarizes the will?
A notary. I'm also a notary, as well as most of my staff. So it can be anyone who has passed the exam for the notary and has the seal.
And who keeps the original of the will?
You can keep it at home, or for some of my clients, the majority of my clients have us keep it in our vaults in the office. So it's really up to you where you want it, but it does need to be accessible when you do pass, that we can find the original. So that's where some people choose not to have it at home. The one place I would say not to put it anymore is the safe deposit box. For years, everybody put everything in their safe deposit boxes. The problem with that is we have to get permission from the state to get into the safe deposit box, and we're allowed to go look to see if there's a will, just to get that piece out first, and then we have to go back to do a full inventory that we have to provide to the state of every single thing that was in the box. So it's harder to get into it when we need the will right away.
Okay, so I die. How does my wife, what's the first thing that should happen after that then with my will?
Well, somebody should call me. That's always a good thing.
Can anybody call you?
It should be the one who's named the executor in the will, which is typically going to be a spouse or children. And we'll talk to the family member. If I have a copy of the will, then I'll know who we need to talk to. So even if someone else calls, we'll tell them, this is the person in the document that we need to speak with. Because that's the person, once they get sworn in by the county, has the authority to continue with the estate and to open it up and deal with the bills. The other, nobody else does unless they're listed in that document.
In my will, should I be putting things in like who should get the piano or who should get that picture?
The answer is it depends. If it's real estate or a classic vehicle, something that's really worth a lot, you would want to put it in there. But if you start putting in all your individual items in the house, like a piano or your television or your jewelry, that's always an important one, because if Pennsylvania sees it in the will, then Pennsylvania says two things. We need to go get that item appraised, get a value on it. So we're going to pay an appraiser to give us a value. So there's money. And then we get hit with inheritance tax in Pennsylvania of who's getting that item on the value that it was appraised at. Again, more money. So I like to not put that stuff in the will unless we need to. And that means, is there family dynamics that require it? Is it specifically, again, for real estate, maybe a vacation home that we need to make sure goes to a specific person, then we will. Otherwise, I tell the family, make a list on a tablet like this, and you can instruct your executor who gets what. You can put sticky notes, put people's names, tape it to the back of the items in the house. We'll follow that, but then we don't have to pay that extra money to the state that we really don't want to pay for.
We'll get back to the state inheritance tax. So where should we put this list that we made up, who gets what?
Yeah. So many of my clients will keep their list in their file with me at the office. They'll keep a copy with me, they'll have a copy at home. I always tell them, keep it with your important papers. Where's your family members going to go to look for your will, to look for your power of attorneys? That's where you want to keep that list. And because it's a private list, meaning it's not recorded anywhere, you can change your mind. So if you decide today you want, your niece to have whatever painting, and then next year you decide, no, I want somebody else to have it, you can change your mind and just write a new list, cross it out.
Or just call you and say, cross it off and write this in.
Absolutely, yeah.
The question then arises, should we be trying to avoid the inheritance tax in our wills?
So when I talk about inheritance tax in the will, we have inheritance tax in Pennsylvania. We can't get around it. We try to reduce it as best we can. And so one of the things that I do put into the will is an actual tax clause of who's paying the inheritance tax. It's preferable if we pay it through the will, through that residue. It's paid before you get your items, before you get your cash, and then it's done. But you also have items with beneficiaries. So your retirement plans, your cash accounts, if you have a beneficiary, they're getting it directly, but they're also going to be taxed on it. So that's what we look at when we're writing the will. Where are the assets coming for the different bills, for the taxes, to make sure we get the right clause in the will itself. Charities don't have to pay tax either. They're like a spouse. They're at 0%. And so I write the tax clause in there to be more beneficial so the charity gets the whole amount you want them to get, not reduced by what the other taxes are in the document. So there's a lot of language to use in there to get the right taxes.
We'll get back to that. One of the questions is, you talked about having a valuable drawer, what do you suggest we put into that, what we call our file drawer or a box or whatever it is,
Yes.
which has, quote, the important papers for whom to know? For
Exactly.
the executor?
It's for both your power of attorney agent, who's going to help you while you're living. They need to know what banks you have and where your accounts are if they're going to be going to the bank for you. So we always tell them, keep all that stuff together. Your healthcare power of attorney agent, who's going to be able to talk to your doctors. They're going to need to know what's in that document too, so they know what they can do for you. And then of course your executor in the will is going to be dealing with all of that when you're gone. And sometimes your agent when you're alive is not the same as your executor. It can be, and it's easier if it is, but for some people they're different.
Are you saying that the power of attorney has nothing to do after I die?
Correct. Power of attorney stops the moment you pass, and then it's going to be the executor in the will who's going to pick up that duty, but not until they're sworn in. So there's always a gap from the time we pass until, if we need to use the will, until that executor is sworn in. So that gap is usually maybe 2 or 3 weeks at the most.
So who fills that gap?
Nobody at that point. Everything is on hold until your executor is sworn in.
I mean, make arrangements with the undertaker? Or
That's always the family. So it's always a good idea to pre-plan funeral arrangements. But again, that's a tough topic, and most people don't want to do that either. But if they do, again, that's paperwork to keep in that important box so that they know who's your preferred funeral home, what kind of arrangements did you make. I have people even put in there what kind of service they want. They list the scriptures and the songs they want, and they've even given me, again, the copies of that for their file too. And so that person is going to be the one, usually it's a family member, who's going to be in contact with the funeral homes. One thing I will want to talk about a little bit is you mentioned cremation. Even when you pre-plan your funeral arrangements with a funeral home to cremate, the funeral home still needs an actual blood relative or a spouse to sign off on the cremation. So that's where sometimes we have to track down a family member pretty quick because maybe there's no spouse left, it's a friend that's helping, and we have to find a family member to sign off on the cremation.
So if somebody has written down there, I want to be cremated, that will work. It doesn't take any more.
Yep.
So that seems to be a basic thing that we all should have decided, do we want a cremation or don't we?
And that's a tough topic too, because there's a lot of people who, they want no part of cremating. They want to be buried as a whole body, and that's okay. But it's making sure that the family knows, because you could have a different family member who happens to be the one in charge of things, making different decisions for you. That's why it's always a good idea to write everything down.
Yeah, I also get concerned of the people who just give the name of a funeral home and then they let that person fully deal with them. And I get concerned when I see funerals that are costing $10,000 and $15,000 and there isn't enough money there to pay the flowers for something. Deal with those things, folks. There's nothing wrong with pre-planning and prepaying for your funeral. I'm speaking for Lee Moyer now. I'm not speaking for Frederick. I'm not speaking for anybody. But you can have it done. You can go to the Cremation Society of Pennsylvania, and for a few $100, all you have to do is call them. They pick up the body. They give you the ashes, whoever it names. It's all done and paid for. But you involve a funeral home today, you're going to be paying $4,000 to $5,000 minimum. If you go through it, if they call the funeral home and say, my dad died and I want to take care of the arrangements. So that's Lee Moyer speaking. So,
and let me add to that too, that if you do pre-plan with the funeral home and you prepay, you're paying today's prices. They will then invest the money so that the money grows as the cost of everything go up. And that's where when the person does pass away and they've prepaid, there's often a refund to the family because there's money in there. You'd rather pay today's rates than rates 10 years down the road, because the prices are only going up. And I don't like to pay more than I have to for anything. Not here for that.
And I would add to that, when you go to a funeral home like that I was talking about, it's probably going to cost you the same whether you have a casket or cremation. You're going to ask you to pay you $1,000 for the urn to put the ashes in and all those things. So, you can quote Lee Moyer, who knows nothing, but saying, save money, prepay your funeral, and do it with Cremation Society of Pennsylvania. Now, the other question that I have is, what do you do with the things that aren't in the will, like the computer passwords, the account details, the investment details, your funeral plan, your burial plans? Where should all of that be kept? And should you put that all in writing?
Yes, it should always be in writing somewhere or accessible. So think about when you can't do things for yourself anymore and you need that power of attorney agent to be helping you. Where are they going to find all of that? That's what they're going to be needing. If you're doing most of your banking electronically, or your bank is only an electronic bank, there's no physical location to go to, your agent's going to need to know how to get in there. And so that's where, when you're at the point that you're ready for them to start helping, is sit down and have that conversation with them on where to find those passwords, where to find things that they may need to use. We have the same issue when the person passes away. The executor now needs to get into those documents. If we can't find them, we're asking these companies to open it up for the executor, and some will not do it without a court order. And that's, again, another expense, another piece of the puzzle that delays things, is trying to get into those accounts. And so the real important thing is, whoever's going to be helping you when you're living or after you pass, you got to trust that person. Don't pick somebody you don't trust, but you should trust them enough that when you need help, that you're okay with them having access to those items. It's going to make it a lot easier when we're dealing with it through the estate process as well.
And you can even go as far as writing your own obituary. Just think how challenging that is to your survivors to write your obituary, to find out what year you graduated from high school, or even where you went to high school. So there's nothing wrong, I say, with writing your own obituary. Now, let's get out of wills and let's talk about those beneficiaries. Now, we got the will, and we've got to decide who's going to get all of our goodies, including our money. So, what's your tip, Michelle?
So when we have those conversations with the family, we're really trying to figure out who do they want to inherit. Because they're going to inherit either through the will or as a beneficiary on an account. And so we have those conversations to say, well, who's involved with your life? And, for some people, they might have only one child that is actively, the other child, they have no idea where, there's family dynamics. And so for a lot of families, they want to keep everything equal. If they have 2 children, they want things divided half and half. They want to make sure everybody's equal. And then they'll tell me what's going on with each child. So we also talk about, is one of the children have more of a financial need? That may split it from being half and half to being 75-25. I mean, it really depends. And we also talk about, well, what other organizations, what other charities have you been either donating to during your lifetime, or ones that you really care about that have been involved in some fashion that you want to include. And so that's where we really hone it down to see, let's make the list first of who we want in there, whether it's organizations or people, and then figure out how much or what you want them to have. And then we just keep working through it until we get it just right for you.
How about if you have somebody, maybe a grandchild, who may be in prison?
Yeah.
How do you deal with something like that in your will?
So when you have somebody that is already incarcerated and they have all these charges on them, they also have a lot of what are called restitution payments. So even when they're sitting in jail, they're still required to make these payments to pay back the different victims. Well, they don't have money when they're in the jail. Everything's already gone. But if they then inherit directly, that's going to go from your will straight to them. That's probably going to go back for restitution payments. So one of the things that we try to do is find a way to safeguard it so that it's there if they need it when they get out, but that it's not going to disappear while they're still in jail. So those are going to be a trust built inside of the will. So the will is going to create that trust for whatever issue that person has, whether it is incarceration or disability or they're a minor, because that type of trust doesn't exist until you're gone and there's funds to create it. So it's not something that we're creating today because we're not funding it, but we built it in there as a just in case.
I had twin cousins who didn't speak for years because their mother in the will gave a higher percentage to the other one because the one lived close by and took care of her all the times, and the other one lived states away. That caused such a friction. How do you avoid a situation like that?
The best thing is when they're writing the will, if we include a reason. And we can put that in the will to say, I'm giving this person more or less because, and explaining it. I sometimes have the clients will write a letter to their children that does not get opened until they pass that explains all of that. We can't prevent if those siblings are gonna, hate each other or not talk to each other for the rest of their life. We can't fix that. But we hope that we can by explaining it and trying to explain that parent's reasoning. And we do the best we can, but it's always best, again, if there's some type of reason explained so that they understand when the time comes why it is the way it is.
Yeah, our family said, well, because my dad in his will did everything even, and it seemed like he had forgotten that he'd given away half the farm to the other person, and so we reminded him and redid his will, but that saved the problem, which would have been irresolvable after the fact, so it would be. Another question that comes up sometimes in this is the dangers of naming actual dollar amounts. I remember when we did this the first time, I wanted to give dollar amounts, and I remember the attorney saying, what happens if you don't have that number of dollars? What do you suggest instead of giving dollar amounts?
And that is the risk of using specific dollar amounts. We don't know what we have to distribute until it happens and we're not here. We might use up all of our money until then. And so it is always better to use either percents or fractions, because then we know what's left in that pot. A little bit's going to go to everybody. If we have dollar amounts, there's two rules of thought on that one. One is you start from the first one on the list in a hierarchy until you run out. Other ones, I don't like to do it that way because then they don't get anything if they're on the bottom. So the other way is we look at it and try to figure out the total that's in the will and what the percentages are, and then we're trying to divide it so that everybody gets a little bit. So it's really a lot easier if we're going to run out of money to put fractions or percentages, because we don't know.
So it's easy to put 10% for Frederick living?
Right, rather than $10,000. There are some people in their wills who will say, I want this specific dollar amount to go here and go here first, and then divide the rest.
Is there anything left?
And then we do the same thing. We see if we have the total that we can do of the cash and then divide the rest of it. So it's a lot of mental gymnastics with the numbers.
I think one of the things that some of us will face is that some of our beneficiaries are no longer alive.
Mm-hmm.
Something about per stirpes and per capita gets involved.
Yeah, absolutely. So when I talk to the clients, I always tell them, let's talk about the what if plan. If this person passes right before you or at the same time, where do we want that piece to go? And the per stirpes wording means it follows the family lineal bloodline. So parent to child to grandchild to great-grandchild. The per capita is going to redivide it between the same ones on that same level, so going more horizontally. And I have some people that don't use either term. They'll specifically say, I want, this quarter going to child A, and if not, then it goes to their spouse, or it goes to a charity. So you can really customize it however you want, but you do want to think about those what-if backup plans.
With whom should the contents of the will be shared? Should that be kept a deep, dark secret until I die?
It's always a good idea if your named executor in the document knows that they are named in the document. A lot of surprises can happen afterwards when you say, yeah, tag, you're it, you're the one named in it, and some people are not ready for that. But if they are going to be your named executor, it's also a good idea that they know where things are, because that's going to make it a lot easier for them. they don't necessarily need to see the will at that point. As long as they know that they're listed in there and this is where things are to find it, but it's totally up to you who you share what with. I mean, sometimes when the kids see the will ahead of time, they get angry. So that's never, you don't want to deal with that drama if you don't have to. But I would suggest as long as the one who's named in the will as your executor or even a backup executor knows where to find things, but they don't necessarily need to see it and read it at that point. Or you give it to them in a sealed envelope and trust them not to open it until the time comes.
How about the beneficiary? Should they know they're named in the will beforehand?
Again, that's a personal decision. I mean, I have a lot of people that are surprised that they're named in someone's will. Most children and grandchildren expect that they would be in their parents' wills, but sometimes they're not. And again, if they're told that they're in the will, that can do one of two things. It can cause family dynamics to change, or it could be that they are now expecting, and they might live their life a different way because they're expecting to get something, and at the end there might be nothing. So, I mean, my job is always to make your life as easy and comfortable as possible. That also goes for keeping the family dynamics as even-keeled as we can, because you don't need added drama if you can avoid it.
No, there's something about naming beneficiaries in the will and also naming them as beneficiaries on the life insurance policy or your retirement account or something. How does that get us into trouble?
You want things to really end up the way you want it to be. So what happens sometimes is people forget that they put beneficiaries years ago on their retirement plans or life insurance. And then when they work on their will, they put different heirs in the will, different beneficiaries, and then they don't always match up. So one of the things when I work with clients is we also talk about how are the items with beneficiaries. Are you trying to keep everything equal in both places? Because a beneficiary is outside of the will. If it's on an account or a retirement plan, that tells it where it's going to go. The will becomes then the backup or for items that are not pre-designated. And for some people, they intentionally have the beneficiaries different. If you go back to thinking the family where you have two children and maybe you don't want things totally equal, well, in the will they'll make it equal because that's the document they both see, but they might change it on their beneficiary so that one child gets one account that has a higher value. So again, it really becomes personal on how we divide things, but we always want to make sure that we did not forget to update a beneficiary designation if it's going to impact the end result that you're trying to get.
Are you saying, Michelle, that what's the beneficiary name on the insurance policy takes precedent over
Yes.
what I say in the will?
Yep.
How about in my pension?
Yep. Anything that you have pre-designated, whether it's a beneficiary designation or think about a joint account. You have someone else's name on as a joint account holder, they're going to be getting those funds directly. The will can't change those. So they're separate. They work together, but they're also separate.
How about in divorce situations?
Oh yes, divorce is fun because sometimes people forget to update their estate plans. But if they're listed in their will and on beneficiaries with the two spouses, and then they start divorce proceedings, it depends on where the divorce is in the process if that other spouse does not inherit. So the law is really clear that if you started divorce proceedings, you're not inheriting, even if they haven't changed their documents. There are also ways to protect an inheritance from the other spouse if you think that the kids are going to get divorced. And so I have some families where the couple got divorced, but they're still good friends, and they still have each other as their power of attorney agents. They're still inheriting from each other. They just couldn't be married anymore. And in that case, we want to make sure the document is clear, because if we don't change it from the original one that calls them husband and wife, the law is going to say you're no longer husband and wife, you don't get to inherit, and that may be not what the family intended. And so we always have to make sure if there's divorce going on for heirs, for the kids, or for themselves as the one whose document it is, that we have everything matched up properly.
So, is there anything in the will, since we're all living here and residents in Frederick living, does it matter what happens to our money left over as far as Frederick is concerned? Does Frederick have any rights to any of our leftovers?
No, so whether you live here or you live at any other retirement community, it's your choice if you leave anything to an organization like Frederick in your will or as a beneficiary. You don't have to, it's not required. That becomes a very personal decision. So just because you live here, that doesn't mean they're saying, okay, now you pass, we're looking for some funds. We're not. It's whatever is still left, with your contract with them or what still needs to get paid each year. That's separate, but it's not that the organization is looking for any payout, once the estate occurs.
But
Often there's a refund from Frederick, frankly.
If all of our money is used here and we're on Medicaid, there really are no assets at that point.
Right, so let's talk about that. So the goal is that we don't run out of money and have to go on medical assistance. That's what Medicaid is. And that occurs if we're at a more of a higher skilled level of nursing. It's called clinically eligible for nursing care is the legal term. But we all call that more skilled nursing, where we can't be on our own anymore. We're really in a nursing side of the campus. And we're starting to run out of funds because it's expensive. As your care costs go up, there are times where we do run out of money. So when you have a resident who's on medical assistance, that means they used everything up. There's not much left in the bank account at that point. But what medical assistance turns around and does when you pass away, they do estate recovery. They're looking to get paid back in full for the full amount that they paid for your lifetime. That's never possible because you may only have $5,000 at most in the bank and they paid $200,000. But they'll still send that bill. They want to get paid back at the state level. And then we have to work with them to see what can they get, what do they get. Sometimes they get $100, sometimes they get $0. And that's what the state has to live with. But we always have to deal with that on the back end of it as well.
Thank you. How about this matter of probating? This seems to be a big issue, and I think you said all the wills in Pennsylvania have to be probated, right?
No.
They don't?
No, so let's talk about what is probate. I always hear from people, I want to avoid probate. Probate is not something to need to avoid, not in Pennsylvania. The probate process in Pennsylvania is having our named executor sworn in if we need to use the will for the assets. So if all the assets are joint with the spouse, you have the spouse as a beneficiary, and there's nothing in individual spouses' names, when the first spouse passes, we don't really have to use the will. So there's no probate. When the second spouse passes, if there's items that are, again, not with the beneficiary and not joint, then we're using the will. So we're using the will if there's an asset that goes through the will. So that means it's not joint with someone, it doesn't have a beneficiary. Or now it's under $20,000. If there's $20,000 in the bank, I can get that out too without having to use the will. We have, again, just have a few hoops to jump through, but we can get it out to the family pretty quickly. And so probate, once that person is sworn in, then the bills are going to get paid. We're going to be working on the inheritance tax. We're going to transfer the funds over to those beneficiaries or to the heirs. And the same process is going to happen whether the will is probated or not. So that's why I always say the probate is having your named executor sworn in if we need to do that. We're still going to do the administration. The administration could be probate or non-probate. Either way, we're going to pay the bills and get all the funds out to the family or to whoever you've named.
Does the state care whether we probate it or not?
No, the state doesn't care. They just want their inheritance tax.
So how do they know how much money they're to get?
It's going to be on the tax return. So on the inheritance tax return, that's where we're going to list all those assets as of the date that you passed. And we have to attach all the documentation to it. They don't take our word for anything. But that's where they're going to find it is on the return.
And the rates are different depending on who gets the money and what those rates are.
Yeah, so it's, for Pennsylvania's inheritance tax, it's 0% between spouses. It's also 0% for charities because they're non-taxable. Then it goes to 4.5%, so 4.5% to a parent, child, grandchild, that lineal line. Then it jumps up to 12% when you go horizontally to siblings. And then it jumps up again to 15% for nieces, nephews, cousins, and friends if there's no relationship.
Yes.
It's you.
You might do it.
Yeah, move your hand off the mic.
Okay.
It wasn't me.
Then something about federal taxes.
Oh, yes.
I doubt that there's very many people here in Frederick that have to worry about that. Why is that true?
Right now, in 2026, we do not get hit with federal estate tax until our estate has $15 million per individual.
All right, if any of you fill that, we want to see you here with that.
So for a couple, you need to have 30 million before we get hit with that estate tax.
So that's one you don't have to worry about, right? Now,
And it was a lot lower. So if you remember, probably 20, 30 years ago, it was closer to 200,000. So as soon as someone had a house, they were hit with federal. And that was back in the 80s. So, you know, it has changed, and every year it's actually gone up on the limit. So for a while, it was only at 6 million. So now it's at 15. So I don't anticipate that going down. So most people don't need to worry about that.
someone said that we can also reduce our inheritance tax in Pennsylvania is by giving things away before we die.
Okay,
That
yes.
seems to make a lot of sense.
Yes, so what happens is, whenever it's still in your name when you pass, that's what we're dealing with inheritance tax. And anything you gave away in the last year of your life. But we don't know what our last year of our life is, do we? If we knew that, we'd be good, right? We could plan for that. But what often happens is, when the person passes, I often have one of the kids say, oh, well, yeah, mom or dad put me on the account like 2 or 3 months ago. Okay, great. When you look at the account now, it shows it half and half, which would be half taxable. But it was added on in the last year. It's going to make it fully taxable. So that's where that last year of life is so critical, that if you're changing things, you get hit with the full value of the tax.
So you're saying that if I put my children's name on my CD, all of a sudden, if I die,
Right, if you die tomorrow, it's going to be fully 100% taxable, not
a year
half
from
and half.
but a year from now.
Right, you've got to get past that year mark, and then we don't worry about it.
And then what happens if I've added their name to it? And when it comes to
If
the
it's more
executive-
than a year from the time that you passed, then it looks at how it's titled. So if you put one child on your account, it's going to look at half and half. So then it'll be half taxable because the child already has the other half.
So when that CD gets cashed in, half of it goes to the child and half to me?
Correct.
Oh,
Because when you add someone to the account, they own it, right? So that could be a problem too. And you have to be careful, because sometimes with parents and children, they'll have joint accounts, but then it's a matter of whose money is it? Because if the child dies first, the parent's going to get hit with tax on half of it, and it's all the parent's money. Inheritance tax doesn't care who put the funds in. And that's where it can be really hard, because I have a lot of clients that did that, and then it's the child who passed, and they got taxed on their own funds.
how does that affect Medicaid if I apply for Medicaid and I have CDs
Yeah.
in my name and my children's name?
Yep. So when we're applying for medical assistance, which is the Medicaid, they have a 5-year look back. So they're looking to see, what did you retitle 5 years prior to needing to apply for medical assistance? And there's a lot that can happen in 5 years, because again, we don't know when that 5 years is going to happen. We don't know when we need care. And so that's where we have to look and see if it was added, let's say year 3, it's within that 5-year window. The whole thing is going to be treated as we have to spend it down, because it's not allowed to be gifting like that. When you get to medical assistance and they see that account has the 2 names on it, and even if it was put on 10 years ago, it's going to look at half and half, and they also will look at whose money is it. So if it's all your money and the kids are on just as convenience, then the whole thing is going to be counted towards you, because it's not the child contributing to the account. A lot of that makes my head spin, because you have to look at who's depositing it in, who's able to access it, and how it can be a mess.
So we probably should talk to an attorney like you before we start giving away.
Yeah, before we start retitling things, let's look and see if it's going to make sense, because sometimes it does, and we do have things retitled with the kids, and other times we have to be a little bit more cautious.
All right, let's go to this whole issue of powers of attorney, which probably is the thing that is of more greater concern to us here than even our wills, but because our powers of attorney are the ones that we're going to be counting on. So tell us what we need to know about powers of attorney.
So let's first talk about the two different types. So you have a power of attorney for healthcare, only healthcare decisions, who can talk to the doctors. And then you also have a power of attorney, I like to call it everything else. Usually you'll call it financial, but that's going to be your general power of attorney for everything that's not healthcare. That will include dealing with vehicles, banking, real estate, utility companies, insurance companies, filing tax returns. So it's really everything in our daily life that we might need help with. Both documents are durable if they're written correctly, meaning when you really need the help, or you've lost capacity, you've got some type of dementia going on, the documents continue to work. When you sign the documents, they're in effect right away. I do not like what are called springing documents. They're called springing documents because you create them now, but they're not in effect now. They spring into action when you need help. The problem with those documents are you have to identify what is that triggering event. And that may not be the event that ever occurs in your life. And so then that person you named really can't help you. So we don't like springing documents. We want documents that when you sign it and you've picked the person that you trust to help you, you're confident that they can help you when you're ready for them to help. And they don't have to jump through extra hoops to prove that you need the help. But you also need to pick somebody that you absolutely trust to either make medical decisions or financial, because those are big decisions to make if you can't make the decisions for yourself. But also remember, both power of attorneys do not stop you from making your own decision. It's an addition, it's extra help for you, but it doesn't replace you. So as long as you're able to do things for yourself and make your own decisions, you absolutely can and should. It's like an insurance policy. It's a backup plan that if we need help, we know we have something in place that can go into action and help us right away.
You talk about somebody you absolutely trust. What happens if we don't have anybody in mind?
I know, I have a lot of clients that will tell me that and say, maybe they don't have children, they don't have family members, everybody's passed away. And then we start going through and see, well, who do you trust? Do you have a good friend that can do it? Sometimes they use one of their ministers, or they might use one of their accountants, or a close friend that they know they can trust. As a very last resort, I have been placed on some families' documents and I am working with them. But often I will try to be the last resort and be maybe on with a family member so that there's more than one of us to help. There's also some organizations that I work closely with that will do that role for people who have nobody, but then they're going to be charging their rates throughout the year to help.
And how about powers for health?
Mm-hmm.
What qualifies someone to be a good person for that?
Again, sometimes people have family members that are in the healthcare field. That's always helpful. But you really want to pick someone that is going to be aligned with what you believe for medical care. Because you have some families where, the parent may not be, for whatever, it could be religious beliefs, it could just be a personal belief that they don't like certain things. So if you think about, I have a lot of clients that are Jehovah's Witnesses. They do not believe in blood transfusions, and that's an absolute no. Well, don't pick an agent, another family member or a friend who's not going to follow your personal beliefs. Because if you're the patient and the doctors say, well, we need to do this transfusion, and your agent says, yeah, go ahead and do it, and that's totally against your religious beliefs, that's a problem. So you want to pick somebody that you know is going to follow what your wishes are, even for regular health care, not just end-of-life decisions. But you can pick people for different roles. So for instance, if you have 2 children, you might say, I want this child first to talk to the doctors on a daily basis, and the other one just as a backup. But for end-of-life, you might say, I want them both together, that they do it as a group. So you have a lot of flexibility, but it's so important to make sure that who you choose will follow your wishes for regular health care all the way through the end. because then you're going to get that friction. If you find after you've chosen the person and you've signed your document that this is not a good fit or something else happened, then change that document. Get that person off, because you don't want somebody still in a document that you don't trust anymore.
What are the biggest decisions that somebody with power of attorney for health would have to make?
For healthcare, it could be that you're in surgery. It's not end of life, but you're in surgery and they're finding something else. And they're going to ask that person, can we fix this? Can we keep doing these different procedures? But it also goes all the way through for the end of life decisions, and that's going to be on the living will portion, the advance directive, is that they need to convey your wishes to the doctor. So the document itself is a legal document, it's not a medical order. So the doctors can never just look at it and do what it says. They have to have that agent tell them when you can't communicate. And so that's where sometimes those big decisions are, what do we do in the very end? And in that document, you have the option to pick what you want. You can tell, those family members, those friends, what you would want and not want. And they do need to follow it. So it's, that's where I say the most important thing is picking someone that you know will follow your wishes, whether it's regular health care or end-of-life care, because you need to have that confidence that who you chose you really do trust.
And should the person that you're selecting, should you be talking to them before you name them?
It's always a good idea. Nobody likes surprises. But we often will do that when the families are meeting with me and they pick someone who's not in the room. I always ask them, did you ask them first? Go and make sure, confirm that they're okay doing it, because they don't have to. And that's where you always want to have a backup, because even if they're named as an agent and the time comes that they need to help, they can say no. They can always say no. And if you don't have another backup built in, you don't have another person that can step in. So you always want to have alternates built in.
Can you name two people?
Absolutely. You can name two people where they have to do everything together, so it's a group decision on everything. Or you can name people that they can act independently of each other. And usually when I do that, I'll also qualify the document so that they know that they can act independently, but that the goal is we want them to discuss certain things first before they act. And so we do explain as much as we can in the document, because when they're looking at it years from now or months from now trying to figure it out, they can follow the instructions we put in there for them.
And what should you do with these signed powers of attorney forms?
So once you have your signed documents, my practice is I also give you a lot of copies, extra copies, because you want to make sure that your agent does either have a copy or knows where to find it. So for my clients, I have you sign 2 originals. I keep one set in my office, because if their families are running to the hospital, it's probably the last thing they're looking for that they remember to take with them. And so I often have families call me, and they're either at the hospital, sometimes the doctors call us, and they're looking for these documents, and we will get it over to the hospital as quick as possible. But as long as they know the document exists and where to find it, then we can always help and assist with that.
Do powers of attorney ever get paid by the client?
They can, depending on what they're doing. But I would say probably 9 times out of 10, the agents aren't getting paid. They're doing it because they're your family. They're doing it because they're your friends, and they're really doing it to help.
Somewhere I read that Pennsylvania has a fee schedule for executors.
Yep.
So executors do get paid, or must get paid, or shall get
So
paid?
your executor in the will, you can control how they get paid. So if you decide you don't want your executor getting paid, we write that in the document. So some families have put right in their will, my executor is not to be paid. Some families write in the will, I only want them getting $1,000. Like, you can absolutely pick what you want them to get. If it's silent, then the executor is permitted by law to be paid, and the state does come up with a chart that they recommend, and even from that, the executor can still choose to take it or not. So unless the document is your will is very restricted in the document of what can happen, the executor can either choose to take it or take a smaller portion or decide not to take it.
We didn't talk much about living wills. What should we know?
Yeah, so living wills, I touched a little bit on when I was talking about your healthcare document. So years ago, healthcare power of attorney was a separate document from your living will. I do them as one document. And the reason is the doctors want to look for one document. They don't want to be trying to look at multiple documents to figure out who can talk to them at what point during your life. So we create one document for everything for healthcare. From the moment you sign it until the moment you pass away, everything's in there. The living will part of it, also called an advance directive, that allows you, again, to name a person to convey your wishes to the doctor if you can't communicate. It only goes into effect when you are at the absolute end stage of whatever condition you have with no chance of recovery. So for most people, that's when they get placed on hospice care or palliative care. It also could be, I've seen it a couple hours till the person passes, but it could also be a few weeks when they're at that end stage. That's when it goes into effect, not before.
Someone asked the question of, is it important that my powers of attorney and my executor know what my will? I should have a copy of my willing.
For the living will.
Living will, yes.
The person who should have a copy of the living will is the person who's named in the document, because that's the person that's going to need to convey your wishes to the doctor. I always suggest when clients have signed their healthcare document that they make sure that there is a copy in their medical file. So often it's when you're going to the next doctor's appointment or you're going in for surgery, they're going to ask, do you have these documents? And so you take a copy, but you let them scan it in. Everything's electronic. And so you walk in the doctor's office with a copy, you walk back out with it, but they will scan it into your file. And that way they know already who they can talk to.
I said at the beginning there were two questions. One of the questions we did not answer, and I'll read it to you. Has there been any changes in the step-up procedure whereby heirs avoid capital gains taxes once they acquire the stocks and the cost basis now is the current market value?
Okay, so cost basis is going to be at the time that the person inherits.
So if you have 100 shares of Amazon and you're giving them now to somebody, and you die and it goes to somebody, the value is?
It's going to be the value at the time you get it. So if it's given to you by your parent when you're still living, and they're still living, that's not an inheritance issue. That's going to be a whole gifting issue. But if they're inheriting it through the will or through the estate or even as a beneficiary, their cost basis moving forward is going to be the value that they inherited it at. It's the same thing with real estate. So if you give your child your real estate for $1, their cost basis starts at $1. Then they're going to get hit with capital gains when they sell it for $200,000. But if they inherit it at $200,000, their basis is $200. So it's always when they actually receive it, whether it's when they're alive or when it's inherited, is going to be the basis.
So it appears to be better to wait till they inherit it rather than giving it to them.
It is. It is better to inherit things than to give it away, just because of the tax issues, yes.
I think we've answered at least the questions, those two questions. It's now past 1 hour, and I said, I've never seen it written anywhere that no meetings at Frederick can ever go beyond an hour, so I'll presume that we have the right to stay longer than an hour. I'm sure at this point that I have generated a number of questions for you, but let me say this to you. There are a number of things that you've learned today that probably were more than you could do them with. Remember, this program will be reproduced, and if you have heirs or executors or powers of attorney, bring them into your apartment when you know that the program, when you can pick it up on your TV and show it to them and share it with them. So you have that opportunity. Everything that we have said here today that's been said has been recorded for you in the future. So take advantage of that. The other thing that I would say to you is, how many of you have a power of attorney for estate? Okay, how many of you have one that you would recommend to somebody else? Put your hands up high. Look around you, folks. Here are the people who will give you names. But the other person also, Michelle has her brochures out there. You know Michelle well now. At least I think you know her well. So don't hesitate to. I haven't asked her this, but if we would get 50 clients from here, would you set up an office here in Frisco?
You know, I often joke about that because I do have a lot of clients that either became clients when they were residents here or have moved in since. And I do often joke, and it's a serious joke to me because there are times when I do try to schedule, if I need to come here, that I can do a few back-to-back for people because I'm here already. And so I do often tease, especially I always tease Mike, you might need one of those empty rooms for me because I'm going to be here all day. So, I do it lovingly as a joke, but I am here. I do go wherever. So, even when I come here, I go to any nursing home, any hospital. I go to, clients' homes, whatever they need, because that's where if they can't get out or they're more in a comfortable setting, then that's what we do. Because again, this is tough stuff. Nobody wants to really talk about it. So we want to make it as easy and comfortable for you.
So, your questions now. Emily's around there with that microphone. Because we don't ask any questions, it means that I have asked every one of your questions, and I know I have. Here's a question right up here, Emily.
And I will tell you, as you saw through this whole presentation, there is a lot of information, and I can talk probably on each topic a few hours. So there is so much. This was a nice brief overview for you.
Put it close to your mouth.
I actually have a couple.
Can't hear you.
Is it on, Emily?
It is.
Is it on?
I think you just have to, I'll hold it for you.
Okay. I have a couple of questions.
I can, I'll repeat it.
I don't know if yours is.
Can you hear me?
Give them to Emily, she'll repeat the question for you.
As far as gifting is concerned, is there an amount that you're allowed to give per year without being taxed?
Yes, so there's...
Give the question.
Yeah.
Yeah, so the first part of it, excuse me, is for the gifting. So the IRS has gift guidelines, meaning every year they change the number. And that number, I'm going to say right now, it's
19,000.
Thank you. I always forget because for a while there it was stuck at 10 and 15. Yeah, so 19,000 means that you can gift, according to the IRS, up to 19,000 a year per person. So you could do that to 2 or 3 people, and it's not going to hit an income tax issue. The second piece of that, which you didn't ask, but I'm going to take you there. Even if, let's say, someone was getting married or buying a house, and you wanted to give them 100,000, that's higher than your 19 for the year. But what you do then is your accountants are going to do gift tax receipts, and they're also going to make sure you stay under your lifetime limit, which is usually closer to $1 million. So there are ways to even gift more than that 19 a year if you need to. The accountants work their magic with the numbers.
But you have to go through an accountant.
It's always best so that they get it right on the tax returns. Yeah.
And the other question I had was, if you have a current will and you want to make like a minor change to it,
Yeah.
can you do it by taking it to a notary and having the change notarized?
Okay,
Or
so,
do you need a whole new?
yeah, so the question is if we want to revise a will. We have a will that's current, that works for us, but we want to make a change. How do we do that? A couple of ways. So if you remember at the beginning, I was talking about the state statute for how to write a will, what needs to be in there, what the requirements are to make it valid. It's got the same requirements for any edits, essentially. So what's happening is some people will do what's called a codicil to the will, meaning you're adding it on. I don't like codicils, especially in the technology age, because I had a will one time, I had a probate that had 10 codicils. From the time they wrote the original will, they changed it 10 additional times. And you have to keep all that together. So you can't lose one of the codicils in that train. I would rather with technology, rewrite the will, get the right information in there, because the laws may have changed as well. And so with the case law that comes out of the court cases, it also helps us know how to write the documents better. So we always like to review it, revise it, but get a new one, easy enough with computers. Years ago when we were doing typewriters, that was harder. Now it's on the computer.
So your suggestion is come and see you or see your attorney?
Come see somebody to have edits made. I also had some people where on their original will, they made the edits with a pen. The court does not like that when we need to probate the will because it wants to know, well, when it happened, when all the corrections were made, and again, double witnesses and all this stuff. And I've had courts throw out the will because they can't decipher what part of it is still valid. And then that defeats the purpose of the document. Then we're back to the state statute, it gets out of your control. So we want to make sure we're following the right requirements. Other questions?
More good questions. Over here, Emily.
I can probably speak loud though.
Well, you may be, but you won't be picked up on the TV.
Okay. Is there a situation where upon my death or my wife's death, where our financial accounts are audited by any government agency?
There shouldn't be. So what's happening is when we do the tax return, we include basically either the last statement that has the date of when you passed, or we get a letter from the company that tells us all the information we need to attach to the return. But just because someone passes doesn't make the documents and the accounts need to be audited. What might happen is, depending on if it's a personal income tax issue, even after you pass, that could get audited on the income tax side, but not on the estate side.
Can you address the trust issue? You had talked about that, mentioned it, but you didn't elaborate.
I know, I can literally talk for hours and hours on trusts. So there's two types of trust. A standalone trust that we can create now. So it's going to have its own trust document. You can think about that one, I'm very visual. So if you think about a box, the box itself is the trust. And we create it now and then we fund it now. That's one way of creating a trust. The second way of creating it is inside of the will. So the will would say, for instance, 20% going to my grandchild. But your grandchild is 2 years old. Then the will say, I'm going to put that in a trust until they're old enough. And you'll choose what ages they receive the funds and who's in charge of it. But a trust generally can be for people who are minors. They can be for someone who is disabled and is receiving government benefits. We don't want them to lose their benefits, so we have a different type of trust for that. I also have trust for people that are dealing with substance abuse issues. So those type of trusts, again, are going to be someone's overseeing their funds, because we don't want them to just, go drink it away or go buy drugs with it. You can even put built into there what they need to prove in order to receive their funds. But a trust itself means someone else is overseeing it for that person for whatever reason. And that person who's overseeing it makes the decision of what to pay and how to pay. So it's added protection when those people need more protection.
Whenever you make a will, and is it okay to make a copy of that will? And they would take that even
So
though...
let's talk about an original will or a copy of a will. What's the difference? The original will is the one that you're going to sign. You're going to sign that in ink. It's going to have the original notary stamps. Everything is the original. It's always best to keep that original safe. We do make copies of that will. So for instance, the clients that have kept their wills in my office, they have a photocopy at home because the original is in my office. We want to use the original at the time we need to open that estate for you when you pass. But if we don't have the original and we cannot find it, something happened to it, it got destroyed, there is a court procedure that we can use a copy in order to use that one instead of the original. We have to prove to the court why we don't have the original, have to prove that it wasn't redone since that date of the copy. So there's a little bit of a procedure, but it can be done. If we can't find it, we can use a copy.
Thank you.
One of the things that I've learned is that if you have made any contributions to a 529 children, grandchildren, that is not considered for Pennsylvania inheritance tax. It's outside of the Pennsylvania inheritance tax.
I think there was another question here, Emily.
My husband has old cars. They're only in his name. If he should die first, do I have to put the cars in my name?
You don't have to. Some families do that because it, again, gets us through any type of inheritance tax issues because it's spouses, but also because a spouse can transfer vehicles pretty easy without having to use the will. So we always figure out what's the best way to do that. If we do not transfer it into your name as the spouse, then his estate is essentially selling it or transferring it to whoever we want. So sometimes we'll do a two-step from the husband to the wife, and then the wife can do whatever she wants. Sometimes we'll go from the husband to the grandchildren. So it all depends, and we kind of see what's the best way and the cheapest way to do it. But you don't have to put it in your name now.
Would it be advisable to put in both names now?
When vehicles are in two names, it's just like a joint bank account. It would stay with the survivor and nothing has to be done until you're ready to. So it could make it easier.
More good questions. Here's one over here,
One
Emily.
over there.
If you have a pet and you don't have friends or family members that may be in a position to take over their care, should you pass, can you have a trust for a pet? Like that would give your executor the power to use proceeds from your estate to care for the animal for their lifetime?
Absolutely. We often write right into the will who is going to take over the care of that pet, so who's going to be the custodian of it, as well as putting funds aside for the pet. We absolutely do that all the time. Yep. Any other questions? I think that's it. Well, again, thank you all for listening to me, allowing me to come. It was my pleasure, and I hope I get to come back again.
Thank you, Michelle.